Alright, so I got another angry comment on my Right to Travel video, and it reminded me that I forgot to keep doing the videos, and luckily, Sean Keenan gave me a case that is always mentioned in these arguments, Chicago Motor Coach v. Chicago, which he claims is a Supreme Court case, blah, 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 that says that you cannot be deprived of the use of travel on the highways. Right off the bat, problem number one. The quote that Keenan and other people cite from Chicago coach case does not appear in the actual decision. And you can check it. I'm going to post the link. It does not appear in the actual decision. This is probably either a summary that somebody got from somebody else. Problem number two, which is a minor problem, is that this is a Supreme Court of Illinois decision. So even if this was true, it would only apply in Illinois. It would not apply in the other 49 states. The third problem is right in the title of the case. This is Chicago Motor Coach Company. This is a case about a bus company that was denied some permits to operate buses on Chicago streets. It does not have anything to do with the right of a private individual to move to use the highway, just to do whatever non-commercial things. The final and biggest problem with the Chicago case is that if you actually read it, it actually states that your right to use the highway can be regulated. And here's the actual quote. Open quote, even the legislature has no power to deny a citizen the right to travel upon the highway and transport his property in the ordinary course of his business or pleasure. Now that's where the right to travel people end the quote. If you read the full quote, here's what it says at the end. Though this right may be regulated in accordance with the public interest. Now another guy left me a comment saying that regulation does not mean licensing or mandatory insurance or vehicle registration, which I'm going to address, because it's a good point to bring up. If you go to Hendrick v. Maryland, which is an actual federal Supreme Court case from 1915, before this, the Chicago case, the Supreme Court in that case makes it very clear that regulation of the right to travel on highways can include the requirement for registration and licenses. This is the actual quote. Because, open quote, the movement of motor vehicles over the highways is attended by constant and serious dangers to the public and is also abnormally destructive to the ways themselves. Let's skip this a little bit. Primarily for the enforcement of good order and for the protection of those within its own jurisdiction, the state put into effect the above described general regulations, including requirements for registration and licenses. So yes, regulation of the right to travel on highways can include the requirement to register your vehicle and get a driver's license, according to the actual federal Supreme Court. So anyone telling you that Chicago Coach Motor Company versus Chicago supports the claim that you don't need a driver's license to drive on public highways is lying to you. That is not what the case says. The case actually says the exact opposite, that your right to use the highway can be regulated.